School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 3 Business Contracts, Unit 6 International Contracts of Sale, Part 1.
After completing this unit, you should be able to explain the meaning and relevance of the contracts for international sale of goods, understand the historical background of the contracts for international sale of goods, discuss the applicable law and rules for international sale of goods, and describe the different model contracts and clauses contracts for international sale of goods. Introduction. The liberalization, privatization and globalization or LPG wiped out the boundaries amongst countries and made the world a global village. There were different substantive laws relating to contracts in different legal systems which will conflict in legal scenario. It paves the way for thinking of uniform laws comfortable to both the parties from different countries when they enter into contract with flexibility and without bias. The transactions of sale at the international level are considered to be the backbone of international trade through international contracts. The contracts are regarded as international contracts when the parties to the contract are coming from two different states or countries. More flexible definitions are possible, such as contracts with significant connections with more than one state, involving a choice between the laws of different states or affecting the interest of international trade. As described in the Hague Principles, one approach to identifying a contract as commercial may be where each party is acting in the exercise of its trade or profession. Another approach is found in the United Nations Conventions on Contracts for the International Sale of Goods, that is CISG, which limits its scope to commercial matters by excluding, for example, consumer contracts such as those for goods bought for personal, family or household use. This definition is by CISG as per Article 2, Clause A. There were two important questions which are vital to be answered when a dispute arises between two parties in an international commercial contract. They are: number 1, where the dispute of the parties is to be heard, that is seat of settlement of dispute, and number 2, what are the law or rules that govern the contract, that is choice of law by the parties. Answers to these questions ought to be made by the parties to an international contract where they opted an arbitration clause in their contract with an intention to avoid the litigation in the local legal system and the application of the substantive law of countries to which the parties belong. International commercial arbitration may be particularly popular because, unlike court proceedings, there is a single, nearly comprehensive regime for enforcement of foreign arbitral awards. Historical background. The differences in laws are the byproducts of different histories, philosophies, and worldviews. Uniformity is often difficult to achieve there. One of the major challenges faced by an international contract of sale is the diversity of legal systems. The conflict of laws exacerbated worldwide because of the global supply chains and contractual networks which operates across the globe. The 20th century focuses on uniform framework to tackle the situation of the diversified legal system. Before the Second World War, Ernest Rabel suggested the possibility of uniform sales law to the Institute for the Harmonization of Private Law. In 1930, The UNIDROIT initiated the project to prepare a law unifying the substantive rules governing international sales contracts under the auspices of the League of Nations. In 1935, the Commission of European Scholars under the leadership of Rabel prepared a preliminary report. Though the Second World War interrupted the work, it was resumed in 1951 in the Hague Conference. In 1964, two conventions, namely Uniform Law on the International Sale of Goods, that is ULIS, and Uniform Law on the Formation of Contracts, that is ULF, unifying the law of international sale of goods were adopted and came into force in 1972. These are still not widely recognized outside Western Europe as instruments of international harmonization. The establishment of UN Commission for International Trade Law in 1968 paved the way to draft a new unified sales law. The final draft of the Convention on the International Sale of Goods, that is CISG, was approved by the General Assembly of UN in 1980 and came into operation on 1st January 1988. The CISG is now supported by a number of conventions like the UN Convention on the Limitation Period in the International Sale of Goods, the 1983 Geneva Convention on Agency in the International Sale of Goods, the 2005 Convention on the Use of Electronic Communications in International Contracts, the 1983 Uniform Rule on contract clauses for an agreed sum due upon failure of performance. 94 countries ratified and acceded to the convention as of 2020. The CISG is the best example of unification of private law till date. There are no statistics available to prove the success of the CISG in developing international trade. The ratification does not mean the unification of international sales law effectively. It provides the contractual parties with a useful or efficient regulatory framework. The CISG is based on the principle of party autonomy. The parties are at liberty to adopt or exclude the applicability of the principles laid down thereon in the CISG. The ratifying state may ratify in total or with certain restrictions, which creates uncertainty to the fact that the convention is a unifying law on international sale of goods. This creates gaps in the provisions of the convention. In international disputes, the national courts and arbitral tribunals have to take the international character and the uniformity in its application and the observance of good faith in international trade into consideration. The CISG does not specify or state a list what these principles are, and consequently they have to be deduced from the other provisions of the convention through a process of analogy. The judge may venture outside the four corners of the CISG and settle the matter in conformity with the applicable law. It is clear that the CISG does not unify the law of international sales in an exhaustive manner, but instead operates in a supplementary and symbolic relationship with national law, trade usage, party autonomy, and other international instruments of harmonization. Applicable law and rules. Conventions. In some international sale contracts, the law applicable to a contract will be provided for in a treaty. The United Nations Commission on International Trade Law, that is UNCITRAL, has created 3 treaties that provide the applicable rules governing certain contracts. They are: Number 1. United Nations Convention on Contracts for the International Sale of Goods, that is CISG. The United Nations Convention on Contracts for the International Sale of Goods is the most widely adopted treaty providing substantive contract rules. The CISG scope is limited to commercial contracts for the cross-border sale of goods. Successful implementation of the CISG requires more countries to adopt it and parties to use it. Courts and arbitral tribunals must interpret the CISG in a uniform manner and not through the lens of domestic laws. Number 2. The Convention on the Limitation Period in the International Sale of Goods. The Convention on the Limitation Period in the International Sale of Goods, that is, the Limitation Convention, is a sister treaty to the CISG. Originally adopted in 1974, it was amended in 1980 in order to operate seamlessly with the CISG. The Limitation Convention applies to the same types of international sales contracts as the CISG with the same scope of application, but its substantive provisions deal solely with limitation or prescription, providing a sort of statute of limitations for international sales disputes. The general period of limitation provided in the Limitation Convention is 4 years. Till date, there are 30 state parties to the Limitation Convention, whereas 84 state parties in the CISGs. As is the case with the CISG, parties may opt out of its provisions. The rules of uniform interpretation for the Limitation Convention generally mirror those found in the CISG. Number 3. United Nations Convention on the Use of Electronic Communications Convention in International Contracts. The United Nations Convention on the Use of Electronic Communications in International Contracts is a much more recent treaty than the CISG or Limitation Convention. Adopted in 2005, it currently has 7 state parties. The purpose of the treaty is to remove any legal obstacles to the use of electronic communications in international contracting, creating certainty for contractual parties that contracts and other communications exchanged electronically are as valid and enforceable as their traditional paper-based equivalents. The scope of the Electronic Communications Convention is broader than that of the other UN citral treaties, in that it is not limited to sales contracts, although it is still aimed at only commercial contracts. Contractual parties may of course opt out of its provisions. Like the Limitation Convention, the rules of uniform interpretation for the Electronic Communications Convention mirror those found in the CISG, making the same general categories of research resources relevant. National laws. Parties may also choose national laws to apply to their international commercial contracts. The party with greater bargaining power may insist on its national laws, or parties may instead choose the law of a third state, usually one considered to have a well-developed law with regards to commercial transactions. English law is frequently used in international transactions, in particular with reference to reinsurance, charter parties and sea trade, among other areas. Parties may select Swiss law because of the perception that Switzerland's political neutrality makes this a neutral law. Nonetheless, political neutrality may not always be the best guide as to the suitability of a chosen law for a specific transaction. The ICC International Court of Arbitration 2013 statistical report mirrors the 2010 survey and also indicates frequent choice of German and French law. When considering these types of surveys, it is important to recall that generally the choice of law of any CISG state will also include the CISG unless the convention's application is clearly excluded by the parties. Soft law and trade usages. There are many international texts and standards that may be chosen by traders to govern their contracts. These rules may be referred to variably as rules of law or soft law or trade usages. but they are connected by their use in international contracting and potential direct application by arbitral tribunals. Even otherwise binding texts such as the CISG may fall into this category when chosen by parties to apply to their contracts without reference to a specific state law. Like arbitral tribunals, state courts may recognize and apply these rules, but depending on the relevant domestic law, they may do so simply as a set of rules that are considered to be a part of the contract and not overriding any mandatory law. The Hague principles where followed may serve to further legitimize some of these sources. The Hague principles in Article 3 allow for the law chosen by contracting parties to be rules of law that are generally accepted on an international, supranational, or regional level as a neutral and balanced set of rules unless the law of the forum provides otherwise, specifically naming the CISG, the Unidroit principles, and the principles of European contract law, that is PECL, in the accompanying commentary. A few of the more prominent texts and standards generally discussed in this category of rules of law or soft law or trade usages are: Number 1. Unidroit principles. The Unidroit principles of international commercial contracts, that is, the Unidroit principles, were first finalized by Unidroit in 1994 and revised in 2004 and 2010. Unidroit continues to revise the principles as appropriate, currently considering revisions meant to deal with specific aspects of long-term contracts. While following the CISG's approach in many instances, the Unidroit principles are a set of general rules for international commercial addition, and they are able to cover areas that the drafters of the CISG were not able to agree upon, such as validity, agency, and assignment, among others. Also, unlike the CISG, the Unidroit principles are not a binding text and will generally only be applied where chosen by the parties or through application by an arbitral tribunal with the authority to do so. Significantly, the Unidroit principles contain rules of interpretation almost identical to CISG, making case law and academic writings of great use in interpreting the principles. In addition, the Unidroit principles have a built-in commentary that gives detailed guidance. The advantage of principles of international commercial contracts, that is PICC, is that they do not favor one particular domestic system of contract law or even legal system, but rather provide a neutral set of rules that combine the best practices from legal systems around the world. The US Citral, on its endorsement of the 2010 PICC, stated that these principles and the CISG principles are complementary relationship and that PICC can be used to interpret and supplement the convention. The 2015 Hague Principles on Choice of Law in International Commercial Contracts, which were adopted by the Hague Conference on Private International Law, might trigger welcome change. Continuously improved since their first inception in 1983, the PICC have been described as a restatement of international contract law. The PICC could function as the new Lex Mercatoria. Lex Mercatoria. The Lex Mercatoria has been described as a synthesis of generally held and generally accepted commercial principles that may be expected to be applied to contracts among the major trading nations. There is a controversy surrounding the Lex Mercatoria and in particular the specifics of its content, but arbitral tribunals can nonetheless, where authorized, apply these principles. Certainly, the content of the Lex Mercatoria may be informed by or in fact contain the content of international instruments such as the CISG and the Unidroit principles. For an example of a contract clause containing choice of such broad principles, consider the United Nations General Conditions of Contract, which state, with regard to dispute settlement, that the decisions of the arbitral tribunal shall be based on general principles of international commercial law. Incoterms. In the specific area of delivery of goods, the International Chamber of Commerce (ICC) has developed a set of rules governing trade terms that describe the obligations of buyers and sellers and supplement any other rules governing the contract. The terms are in combination of 3 letters. One example is FOB, standing for Free on Board, and the Incoterms rules cover who bears the risk and obligations when the seller has contracted to deliver goods in this way, namely, on board the vessel nominated by the buyer at the named port of shipment or procures the goods already so delivered. The Incoterms come with the instructions as to how parties can incorporate them in their contracts. There have been many versions of the rules, and the most recent are the Incoterms 2010 and 2020. They were first published in 1936. Incoterms 2010 defines 11 rules. They are upgraded as per the trade practices. The Uniform Customs and Practice for Documentary Credits, that is UCP 600. This was another creation of International Chamber of Commerce for the convenience of international trade. The Uniform Customs and Practice for Documentary Credits 2007 revision UCP 600 is the soft law instrument for regulating letters of credit, a common payment method in international transactions. The contract must indicate the application of UCP 600 towards the credit document. It contains rules specifically for electronic goods.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course Coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.